Did you know that what you tell your lawyer is protected in two different ways? One, by the rules of evidence, and another by the rules of professional ethics. Understanding the difference could save you from an accidental waiver. First, attorney-client privilege. Think of privilege as a shield in the courtroom. It's an evidentiary rule that blocks anyone, including a judge or opposing counsel, from forcing disclosure of confidential communications between a client and their lawyer for the purpose of seeking or giving legal advice. Now, the key elements here are, number one, you gotta have a communication. Words, documents, even emails or texts. Then you've gotta have it be between an attorney and the client, or their agents such as paralegals. It must be for legal advice, so business or social chatter is not covered, and it must be intended to be confidential. If a third party sits in, you could risk losing that protection. Who owns it? The client. Only the client can waive it. So what are the major exceptions here? The first is crime and fraud. If the client seeks advice to commit or cover up a crime, then you've got waiver by disclosure and certain joint client scenarios. Okay, let's move on to the duty of confidentiality. When talking about this confidentiality, it's a rule of professional conduct that is even broader. It requires lawyers to keep all information relating to representation private, whether or not it's privileged, and whether or not it came from the client. So in terms of scope, it includes facts that are learned from third parties, work product, and even the existence of the representation itself. Now, for duration, this continues after the attorney-client relationship ends, even after the client's death in most jurisdictions. Now, of course, there are exceptions, which are very limited, I must note. A lawyer may disclose to prevent reasonably certain death or substantial bodily harm, or to prevent certain financial crimes, to defend against malpractice claims, or if the client gives informed consent to disclose. So why does this distinction matter? Because privilege is actually much narrower. You could lose it and still leave your lawyer ethically bound to keep quiet. But opposing counsel might subpoena the same information from a third party. Conversely, if you waive confidentiality by publicly revealing a secret, you may also destroy that privilege. Knowing where the line is helps you protect both. So just remember, keep it private. Don't copy friends or business partners on emails to your lawyer. You can always label any legal communication, mark it as privileged and confidential, legal advice requested, that covers you there, and ask before you share. A quick call can prevent an accidental waiver. I'm a corporate business attorney, and I hope this cleared up the difference between attorney-client privilege and confidentiality. Protect your rights, be strategic about what you share and with whom you share it.